Okay, can you hear me now? Okay. Hey, wasn't me. I'm pretty good at mic, right? All right. Okay, we're on item C on the Enforcement Committee agenda. C, update on the board's agenda implementing California Business Profession Code 4129 regarding licensure of outsourcing facilities. Effective January 1st, the board received the authority to license in-state and non-resident outsourcers. This is an entirely new function and license from what the board has licensed in the past. The board believes it will receive 3 new staff members, 2 inspectors, and 1 supervising inspector for this program beginning July 1st. The committee discussed how the outsourcing facilities will be regulated, including compliance with CGMPs. So the difference between the 503A and the 503B, while the 503As follow state law, 503Bs follow CGMPs, which is the FDA regulations. The committee was advised the board had received 28 applications for outsourcers. 5 of these are in California. So we talked about this at the board meeting, and the inspectors we're going to have are going to be knowledgeable on CGMP.
They have to be. That's what they enforce too.
So are we hiring people that have that level of expertise, or how are we going to know? Because this is a very, very critical, distinct regulation, law.
So what we're doing is we're sending people to all the training we can find. We have not found anyone that has applied that is trained to do CGMPs, but we have collaborated with the Department of Public Health Care, which has a unit set up to regulate manufacturers in California, and they do inspections for manufacturers in California. So we're working with them to get some training for our inspectors that are doing outsourcing. The FDA has given us 3 training spots for outsourcing training, which is an 80-week course, 80-hour course, 2 weeks. 80 hours is a little, yeah. Well, we're never going to see that inspector again. So the goal is to get them trained, and then we're also sending them out together with 2 so that they can train each other in part, and then we're also going out with the FDA whenever possible.
So in terms of they're out of, 5 of these in California, so that means that there's 23 of them that are going to be outside of California.
Yes.
So these individuals are going to do a lot of traveling.
They are.
And their travel fees will be paid by the
company
outsourcers.
Before we go. Mm-hmm.
Okay.
One of them anyway. I think we're only charging for one of the inspectors to go. We're sending the second one as a training exercise.
Okay. There's actually a really good course that Critical Point does on 503B. I just sent a pharmacist there. So.
We're talking with him. He's also talking, well, that's a different subject, but we're talking with him on training for a couple of different matters. So.
Okay. Any board member comments? Public comment. Item D, discussion and consideration, the USGAO's March 31st e-supplement to Congressional Committee on Drug Compounding. Just a GAO report that we reviewed. There's a copy and a link. I don't think there's anything. It's just an explanation, just for information.
Right.
So are there any board member comments regarding this report? Public comment. Presentation by Roadrunner Pharmacy regarding compounding for veterinary prescriber office use. Roadrunner Pharmacy presented at the compounding committee for veterinary prescriber use at a future meeting. I don't know, but I got the feeling, and I don't know those of you that were at the compounding meeting, that they're actually more like a 503B because they are providing pharmaceuticals compounding for a variety of states. So it was a little bit different than just a pharmacy providing that information. They provided a presentation regarding its concerns about the board regulations related to the requirements for establishing beyond use date products, including the need for method suitability tests, container closure integrity tests, and stability studies. And I even got the feeling from some of the other pharmacists that came up and testified that they did not consider them just like another pharmacy. It was more like this is a 503B or a mass producer of some of these agents. So I think we have to kind of look at both of those things when we consider. Part of the presentation, representatives highlighted some of the challenges for compounding medications for animals, and they said that the costs of doing some of these testing in terms of extending the BUD or the beyond use date could be a dramatic increase in cost to pet owners. And as part of the discussion, the committee was advised that the current regulations are consistent with USP 795 requirements. So in this situation, though, Jenny, this pharmacy is providing patient-specific medications to the
I'm not
doctor's
sure they are. I'm
offices,
not sure
or
they
are they providing medication to the vet's offices under an outsourcer?
Well, they're doing it as a compounding pharmacy, but whether they should be an outsourcer is another question.
It sounded like they were doing prescriber office use.
Yes, but keep in mind that the outsourcing isn't set up for animal compounding either, I believe.
Yes. Oh, good. You can actually, great. Could you answer the question? So I think you guys are applying for a 503B, right?
We're currently just a 503A, which is
But you're
Roadrunner
applying. I
Pharmacy.
thought there was some testimony that you were applying as an
Correct.
outsourcer.
Correct. It's in the process.
Okay.
It's built. Our next step is to get it licensed in all 50 states. So currently, we're operating as only a 503A.
So are you doing patient-specific, or are you doing?
Both.
So you're doing prescriber office use?
Correct.
Okay. So the committee heard comments in support of the request as well as opposed to the request, and I think there were some pharmacies there that actually testified that said they were 503As as well. So the committee decided is recommending that we have a special meeting of the Enforcement and Compounding Committee, or actually Compounding Committee, to discuss several different aspects of the board's compounding regulations, including some of the dating that we have in terms of USP 795 for oral medications for humans. And that is actually scheduled for June 2nd
Yes,
in Orange County.
in Orange County.
So there will be a special compounding committee that will be scheduled on that date to hear that specific compounding concerns. Attachment 9 includes a copy of the Roadrunner Pharmacy summarized statement, an excerpt from the January 24th board meeting minutes, as well as the relevant law. Any board member comments?
Do you do sterile compounding or just non-sterile compounding?
Both.
Both.
So
Yeah,
under-
and our major concerns about the new BUD testing, it's above and beyond what's expected out of USP. And we've asked the laboratories about their expert opinion about these, and they don't see, the extra cost isn't giving you any extra value in the testing. And potency over time has been accepted, for the last 14 years. And we do business with the entire nation. We probably do work with over 2/3 of the animal clinics nationwide. And the potency over time testing has not been a problem.
So in terms of your 503B activity, do you still, when you do become that, and you do prescriber office use, not patient-specific, do you plan on doing these studies, or is it concern for both?
I'm not real familiar with the studies in terms of CGMP. So we would obviously have to follow their standards.
Okay.
Oh, okay, sorry.
Any other comments?
No, well, I just want to thank you guys for allowing us to do our presentation last month and kind of presenting some of the insight of the new California regulatory mandates that it makes it difficult on the veterinary community. Look forward to the June 2nd meeting, I guess.
Thank you.
Yep, thank you. Is this your handout? Yes, it is. I do have the handout there that kind of goes over the specifics in terms of USP and the new 1735 regulations.
But this does not apply, this is for a 503A,
Correct,
not for under CGMP.
correct.
Okay. And more, I think what I'm seeing happening from the FDA is that they're moving more towards large-scale compounding and office use to go more to a 503B.
Sure.
The 503 seems to be very patient-specific.
Sure. And a majority of our office stock products will be moved over to what's called Atlas Pharmaceuticals, which will be the 503B facility.
Did you have questions, Alan?
No. Well, in a way, will your 503B concerns mitigate any of these 503A concerns?
I'm not sure.
Okay.
we're fairly new to the 503B, especially in my position as a sales rep. I'm not there at
Ah,
the
okay.
facility. I'm out here in California.
What does clean mean?
I don't know. It was referred to in your regulations. I was asked the same
Clean
question.
1735.
Yeah.
I think I think there's some error there in translation. Clean language, clear language? I don't know.
It was just cited in your regulations, and that they put it, that's how they referred it to.
The
Without the
ramifications,
strikeout and underscore, my guess is.
okay,
Madam President,
yes.
would it be, given that we have some non-pharmacists around the table, that give a quick explanation of the difference between an A and a B, 503A, 503B?
Yeah, that's a great idea. Thanks, Stan. The 503, and this is the FDA changes that have happened. 503A is patient-specific, and it's regulated by the states and their licensed pharmacies. 503B are in between a pharmacy and a manufacturer. So it is licensed by the FDA, and that is regulated under different standards, which is CGMP. So for many years, we have had them, CGMP is the good manufacturing pass of the FDA. So they're very, very stringent. They're kind of the same standards they hold manufacturers to. So that's why I had asked Jenny about the training that we have for the inspectors that are going to be doing CGMP, because it's not just sterile USP 797 or USP 800. It's a lot more strict. And then the FDA is now looking at, so there may be some regulations within our licenses. For example, the centralized hospital repackaging. More and more, they've put in this 2-mile radius or 1-mile radius that the FDA has said. That may affect our regulation, which allows 75 miles. So we may have to look at our regulation in the future because of the fact that the FDA, and I don't know, has the FDA come out with a 1 mile and confirming it?
It was only a draft guidance. There's been a lot of pushback on it, but I've heard rumors that they're not going to go as far as 75. But they might expand it out a bit from 1 mile, but it will not be anywhere near 75. But at this point, it's all conjecture until we get something. We can wait for the bad news like that, because that's going to eliminate a licensing program for the board.
Just in some of the states that I've been hearing are actually citing pharmacies for exceeding the 1 mile. That's why I was asking.
Oh, it's
whether
only a
that's
guidance
been-
document now. That's interesting.
Yeah. I'll get you some more
Yes.
details.
So in relation to your letter, so I see the two different, are you suggesting that 1735 is more stringent than USP? And so are you asking that we,
We eliminate those requirements. We get it for the sterile products, but with the non-sterile oral products, we think it's a overkill.
So what he's talking about in 795, it says unless there are published studies that support it, you need to do these studies. So one of the things that came out at the enforcement committee is that we probably need to hold the special meeting just to delve down into what that means. Because if we have an oral preparation, because there's other impact to this on the oral side, so for the adults or even kids, a lot of kids have compounded medication. And with the USP 795 interpretation that's here, we have cases where we heard at the meeting where people are having to come back every 14 days and get their medication, because without doing these studies, you only have a 14-day expiration.
Yeah, how far, is there some average as to how much longer beyond use date would be? For example, instead of 14 days, is it 21 days that you're trying to get, or is it 6 months, or?
It would be, in most cases, I believe, 180 days.
That's
think
6 months.
It depends on, like, if it's in sterile water or if it's in oil, because that's one of the testimony we heard. I think there's a limit in terms of how you mix it. And then there's also some published references that we use in pharmacy that actually give stability studies on the drug. Remember, this is not sterility, this is stability of the
I
drug.
understand.
So there are some published studies. So USP 795, some of the pharmacists that testified said our interpretation is if it's in trissels or some other compounding reference, if it says it's stable for 4 months, why do I have to do these method suitability tests to do stability when it's already published? So that's why we're having this, because from an
But I
impact to
thought
patients.
if it was published, they didn't have to.
No,
do
that's
it.
why we need to have we need to really delve and talk about it at this meeting.
Well, part of the problem is how it's being enforced, too. And so I think this meeting will clarify that and allow that body of published literature.
I think Al makes
Really
a
talking
really good
about
point.
Concern over effectiveness of the medication as
Of
opposed
the
to.
oral medication, when we're talking about
Right.
sterile, but this is being applied now to oral medication. So if you have a pediatric patient who's getting a medication that you have to compound because they can't, they can't take an oral tablet, you can only give it 14 days dating. So
Right.
what's happening is the parents have to come every 2 weeks to pick up
But
supplies.
But
the
USP
reason behind it is not that it goes bad, it just becomes less effective. That
Yes.
would be the concern.
Not necessarily.
Not necessarily.
Necessarily at all.
It's more a bureaucratic requirement. It's an artificial limit.
Got it.
We need to just clarify 1735, essentially, for oral.
But USP says if there's documented studies,
Yes.
then they're okay with extending the date.
In the absence of published studies, then you use the 14-day for aqueous
Right.
solutions.
But if you have studies, like you said, then you go with what the study.
So what we need to do is look at that and talk about it at the
See, that's
meeting.
what
Yeah,
USP says.
But USP says that,
If there
but
is a study.
1735 says you have to do the testing whether there's published studies or not.
exactly. That's what Greg's saying is exactly correct. So that's what we have to delve into deeper.
1735 says you have to have it either way.
Either way.
And USP says with the
Only
studies
if
you
there
do.
are
So what is
published
likely going to come out of this meeting is we will come back to the board with recommendations to modify 1735.
It's a good idea.
So I would kind of recommend that it sounds to me like this is the whole point of what is going to happen at that June
Yes.
2nd
Right.
meeting is to have this discussion and have it
Yes.
fleshed out so that we have all of the
I kept saying
Accurate.
that.
information.
So we're going to talk about it at this June 2nd meeting. So I hope you'll be there.
I may or may not. We
Okay.
have representatives.
Or a
in Southern-
representative.
Yep. All right, thank you.
Thank you.
How often is USP updated?
Depends.
That's
797 was updated a few years ago. It's being updated now. It just depends on
So
when
will our
new
regs
literature.
move, so as it's getting updated, does that create like a whole new?
That's why we've had to update our regulations for sterile compounding, is to be able to do that.
I think keeping our compounding regs current is going to be an ongoing labor of love for this board. So learn to love it, Debbie.
Okay.
And even our prescriber office use regulations may get impacted
Yeah, exactly.
by all these changes that are happening at the federal level.
Yeah, I think it's just something we're going to have to continue to be involved with.
Yeah, and the June 2nd meeting was actually we were going to discuss it at the next enforcement committee, but the members that were there asked that it be done sooner, so that's why we scheduled a special meeting in response to the public request. Any public comment on this item? Good afternoon.
First, I just want to clarify, when you are discussing 503A and 503B facilities under the Drug Quality and Security Act, that only applies to human? Oh, sorry.
Yes, you're right.
That only
I
applies to
apologize.
human
Thanks for that
compounding?
clarification.
So a pharmacy like
Yes.
Roadrunner Pharmacy that is only doing veterinary is not actually practicing as a 503A facility. Nevertheless, they are regulated by the state, but there is no provision under the DQSA that regulates veterinary compounding.
Say that again, please.
Under the Drug Quality and Security Act, the Drug Quality and Security Act only applies to human compounding. So for a pharmacy like Roadrunner Pharmacy or many of the other veterinary exclusive pharmacies in the country, it is not correct that they be classified as a 503A or B facility because while they are regulated by the state, they are not technically a 503A facility.
Oh, I see, I
Okay.
see what you mean.
So-
Well, since you're up here, I was just talking with Ann regarding the, I guess it's the FDA guidance that these criteria for animals compounding have to be more or less the same as human compounding? What's the enforcement here? And
Right now, there is no actual law, federal law, that governs veterinary compounding.
Okay, so
Are
it's,
are you a veterinary compounder?
Yes, I am.
Okay, and you are with?
Allow me to introduce myself. My name is Michael Blair. I'm here speaking for myself, but I am currently the Vice President of the Arizona State Board of Pharmacy, and I'm also a compounding pharmacist that specializes in veterinary medications. I want to make clear, before I go any further, that my opinions are my own and not those of the Arizona Board of Pharmacy. I'm not authorized to speak for the board, nor do I make any claim to do so. However, as a Board of Pharmacy member, I fully appreciate the mission of the California Board of Pharmacy to protect the public safety. And I think as a compounding pharmacist and a board member, I bring a unique set of skills and perspective to that mission. But more questions?
so now
Can we
the,
talk, no, let me ask Laura, can we talk about this? Or I want to make sure we fall within,
The agenda item, if I understand where you're at, is really focusing on this, the fact that what you're doing is going to have, are we still talking about the?
Veterinary compounding.
Compounding?
yeah, I'm just wondering, can we delve into veterinary compounding questions?
No, I don't think you can. I think you can hear public comment and you can decide whether or not you want to put something on an agenda for future.
I'll continue.
Presentation by Roadrunner Pharmacy regarding.
Correct, and the presentation, really what it was the presentation that was given to the Enforcement Committee, not that it's being re-given. I think that there were some clarifying questions, which is sort of why I said, well, we don't want to go redo the committee's work, right?
But he can provide us with public comment.
Yes.
We just can't ask the questions unless it's related to Roadrunner.
I think you just want to be thoughtful about how far down the rabbit hole you go, yes.
Okay. So go ahead.
I'll finish my comments, and then if you have questions, because there is a lot of confusion all over.
Thank you.
Okay. One important aspect of public safety is patient access to necessary medications. California's current regulations regarding establishment of beyond use dates have had a profound impact on patient access to compounded liquid and sterile preparations. This impact is most apparent when viewed from the perspective of those patient groups that require compounded preparations the most: our pediatrics, our postmenopausal, and our pet owners. These patients have established relationships with pharmacies and pharmacists that must now be abandoned because these pharmacies cannot comply with the new regulations. Patients who have received compounded preparations from the same pharmacy for years with no adverse events have found that compounded preparations they used in December 2016 are no longer acceptable in January of 2017. Since local pharmacies have been impacted the most by these regulations, many patients are turning to pharmacies located outside the state of California, some of whom are shipping compounded preparations into the state disregarding the current beyond use date requirements. Another interesting phenomenon that's arisen nationally in response to decreased access to compounded preparations is that of compounding by non-pharmacists in non-pharmacy settings, for example, physicians' offices, dentists' offices, and veterinary clinics. While these health professionals certainly understand how to compound, it is unlikely that they have the training, time, or facilities necessary to provide consistent quality preparations. Likewise, the expectation that these professionals will abide by USP standards and California Board of Pharmacy regulations is unfounded, and oversight of these practices by the Board of Pharmacy is unclear. Regulations that drive the practice of prescription compounding out of the facilities built for such practice and away from the professionals trained for such practice is, again, not in the best interest of public safety. 2 weeks ago, we sat in this room and listened to comments from California pharmacy owners who were turning away longtime patients and ceasing compounding operations because of their inability to comply with the new regulations. We heard a presentation from Roadrunner Pharmacy pointing out the inconsistencies between sections 1735.2 sub C, 1735.2 sub I, and 1751.8. We heard from a number of veterinarians who complained that they and their patients can no longer obtain the compounded preparations they need for the successful treatment of their patients. And we heard from several board members who were astonished by these unanticipated consequences, so much so that an emergency meeting of the Enforcement and Compounding Committee has been called for June 2nd. When access to necessary medications is restricted, patients suffer. USP does require taking stability into consideration when assigning beyond use dates, but it does not mandate specific testing. True stability tests are appropriate for products that will sit on a shelf for 2 years or more before use, but not necessarily for preparations that will be consumed in 30 to 60 days or that have been prepared for one patient. Published studies addressed a small percentage of the thousands of compounded preparations pharmacies are called upon to provide. While I agree that it is important to have a scientific basis for the establishment of beyond use dates, that basis should not be so onerous as to prohibit patient access.
Coming to our,
There will be somebody here representing my company, yes.
Thank you.
Thank
Well
you.
presented, thank you.
Thank you.
Thank you very much. Appreciate it.
Any other public comment on this item? Moving on to item F, discussion and consideration of the proposed FDA rule list of bulk drug substances that can be used to compound drug products in accordance with Section 503A of the FDA and proposed lists. Under Section 503A, a bulk drug substance that's not a subject of USP or NF monograph or is not a component of FDA-approved drug cannot be used in compounding unless it appears on the list promulgated by the FDA. This is a guidance that was actually discussed or distributed. The committee did not take action and will make the information available on the board website. Attachment 10 includes a copy of the guidance documents. Any board member comments? Any public comments? Item G, another FDA guidance, which is in attachment 11, which is the interim policy on compounding using bulk drug substances under Section 503B of the FDA guidance for industry and proposed lists. Attachment 11 includes a copy of the guidance. The committee did not take action on this as well, and the item will be added to the board's website for FYI. Any board member comments? Public comments? Item H, discussion and consideration of the FDA guidance for industry compounding animal drugs from bulk drug substances. This is a guidance that the FDA does not intend to take action if a state licensed pharmacy, licensed vet, or outsourcer compounds animal drugs from bulk drug substance if operating under specific conditions, and those are listed in there. In a pharmacy, the animal drugs are compounded under the direct supervision of a pharmacist after receipt of a prescription from a vet or based upon prescribed prior experience. If the compounded drug is not used for food or for food-producing animals, if the bulk drug substance is part of an approved animal or human drug, there is a change from the approved drug that provides clinical difference, and numerous other factors detailed in the guidance. As part of its discussion, the committee discussed this guidance as part of the context of the Roadrunner request that we just discussed. The committee heard concerns about the conflict between the board's compounding regulations that allow compounding for prescriber office use versus the guidance issued by the FDA that is outside operating as a 503A of a pharmacy versus a outsourcer or compounding pharmacy. I don't think there was any decision taken by it was an information. Any board member comments?
I've got a comment here regarding, it's kind of a general question based off of this. When we have a FDA guidance for industry, and it says draft, not for implementation, from prior meetings, I've got the, the information that's been given to us. I'm kind of confused whether a guidance for industry is something that's going to actually be inspected to, or rather it is indeed just a guidance. It seems like from a number of compounders, we've gotten a variety of answers on this, and this applies to several of our regulations. So I'd like some clarity on that. I don't know if it's possible to get clarity on that, but.
Well, I don't think I'm the one who's going to be able to give you clarity. The
No,
FDA,
no.
the FDA puts the guidance out there. They say that it's instructional, but they enforce to that guidance. If they're so inclined, they will enforce to that guidance.
I think he's asking if our inspectors are going to enforce to this.
We're not currently enforcing to this. But the FDA is, and that's part of the difficulty where you end up with something that differs from our regs. And the most clear-cut example I can give you of that, Ellen, is a situation where we have pharmacies that are doing office use compounding, which they're allowed to do in California. But if they're doing office use compounding as a pharmacy and not as an outsourcer, the FDA will come in and they will pull out their guidance document on sanitary conditions, which are essentially CGMP conditions, that basically hold that pharmacy, because it is not doing patient-specific compound, it is exempt from being covered by the Food, Drug, and Cosmetic Act for purposes of compounding for a pharmacy, which means you have to have a prescription in hand in order to do it. And so they will cite them for basically good manufacturing practices. And there have been several pharmacies that have gotten letters and discipline for that from the FDA.
Oh, I know, and it's kind of whimsical the way they go about it, too, so.
Well, it depends on where you are with
Yeah,
whimsical,
yeah.
but yes. But I think this is something we're going through a transition. They're trying to transition the whole practice area to a different set of standards. We're trying to learn where the FDA is going, and simultaneous to all that, they're developing all of this. So the one thing the FDA does do is they'll tell us generally when they go into a pharmacy. And we know that if they're going into a pharmacy, most times, if they're not a 503B, they're going into a pharmacy because they're doing non-patient specific compounding.
You know, that's specific example, but it still doesn't answer my question, and I don't expect you to answer my question.
Well, I can't answer for the FDA. You got the
Right.
wrong agency in the room.
Yeah, and isn't there somebody from the FDA in this area that can give us some guidance on this?
Well, we can invite them to come, but generally, I'm not sure they'll come.
Well, we can invite them, what the heck?
I can invite them. Is that a request for the next enforcement meeting?
That'd be great, yeah.
Yep.
If they're willing to come. All right, moving on. Any other board member comments, public comments? And last item is enforcement statistics. Attachment 13 contains the statistics describing the enforcement activities of the board. The board it has a number of investigations, applications, et cetera, on there. One of the things, I mean, when I was looking at this, it seems like in terms of revocations, most of these are technicians. I think it's 96. That was compared to 11 pharmacists that had their licenses revoked during this time period. The other thing is that the drugs of choice seem to be more heavily now on the alcohol side. If you look at the pharmacists, in terms of licensees with substance abuse problem who are either on board probation or participating in PRP, the largest number on the pharmacist side was alcohol. And then the intern pharmacists, all of them were alcohol. And the pharmacy technicians was also alcohol.
Are those from the pharmacist recovery program, the SB 1141?
1441.
Yeah, okay, so that's a separate kind of statistical reporting, but yes.
Yeah, it looks like it's, so we're doing alcohol monitoring on there. There's also a list.
That data would be collected based on what we know of the underlying cause. So unless they self-report something else, it would be limited to just that.
Does this mean that this is what they're being monitored for during their probation?
So generally, when we take action and someone is placed on probation, the random drug screening, which would be one of the primary tools, it's not, the panel itself is not limited to just alcohol.
Okay.
Test for other
So
substances
this
as
could
well.
be someone who had a hydrocodone problem, but they're testing positive for alcohol?
Or they were, yes, it could be, yeah, so, given the types of tests that we do, but generally what I believe is reported here is what we believe their substance use would be, the primary would be alcohol versus hydrocodone or something else.
Okay. Any board member comments regarding the enforcement statistics?
I have a question.
And how do we find out those DUI cases?
So, as a condition of licensure, everybody does fingerprint background checks, and then as a condition of renewal, people certify. So when we will receive a subsequent arrest notification, and then we'll do an investigation, and then look at the circumstances surrounding the underlying behavior, and then determine whether or not the issue is substantially related to the practice or the license that they hold, and then from there, we'll go forward.
But as I remember, you told me last time that usually when they first get the first one, we send them a warning, did we?
So it will depend on the egregiousness of the violation will drive what the outcome of a case is. So we have various outcome options. It could be in any case, and I'm speaking in any case, not specifically to a DUI, but in any case, we can close something with no further action. If we don't substantiate violations, it's closed a different way. We can issue a letter of admonishment, a citation and fine. For egregious cases, we're going to refer them to the Attorney General's office to remove or restrict the license. So it really depends on what our findings are and how egregious the violations are. And then we look at also, as part of our guide, what pharmacy law prescribes. And so we're looking at the unprofessional conduct codes, we're looking at the general BMP codes, as well as we do have some unprofessional conduct detailed in our regulations as well. So we're looking at all of those things and then taking into context the disciplinary guidelines and all of the other policy areas that the board has.
Alan, did you have a comment?
Well, no, yes. Matter of fact, I do. Well, no, it kind of builds on this because I'm not sure that really answers Albert's question there. It seems like there should be something a little more defined. It seems kind of nebulous the way it is. When my egregiousness might not be Ann's egregiousness. I have a higher standard, I'm sure.
We know about your standards, Alan.
And it's very difficult. And so I do think it is kind of a concern. While it's no reflection on the action that's been taken, I think personally, I would feel a little more secure if it was a little more, if we had rules that were a little more defined. I don't know if that's possible because of if it have to be statutory or because it seems like alcohol abuse, it falls into such a broad range, and whether that's going to affect the public or not is more or less up to the staff. And so from what we see, I'd feel a little more comfortable if we had some more defined parameters on that. You think that's possible?
So the problem with that
Yes.
over
Yes.
here.
Oh, hello there.
The problem with that is that any two cases may have factors that are completely wildly different. Taking the example of a DUI, you may have somebody with a .08. That is a DUI. You may also have somebody right next door with a .3 or a .35, or I've even seen a .4 with a car accident, with kids in the car, with injury or even death resulting from the accident. How can you put a policy into place, and you would have to put it in regulation or into the law, but how could you put a policy in place saying you're going to treat those two individuals the same?
No. I'm asking how
Can't.
you're going to put it into place. No, you're not asking me.
That's exactly right. It's
Yeah.
not really possible.
I think that's a common thing to think about in discipline, and that's why you have your disciplinary guidelines, because they reflect sort of the range of what's normal. There could be those incredibly extreme circumstances, especially if you put in that maybe prior violations, prior notices, prior discipline, maybe
Right,
even other things, or maybe the case happened 20 years ago. All of those things factor in, and every discipline case is different. And unfortunately, I think the struggle that you're having is in discipline cases, you can't usually do a cookie cutter. You have sort of broad guidelines, and that's
Sure.
what you have to use, because each case is different.
Well, and that's one reason that we go before an ALJ as well, because you may have even two very similar DUIs, 2.08s, where one person walks in and says, I don't have a problem, you don't have any authority over me, and the other person walks in and says, I've done all the work, I've gone to AA. Those two people should probably not be treated the same. But that is a judgment call. That's a call for your finder of fact, and that's a call for your board once you're reviewing the full facts and circumstances of the issue. It's not really something that you can put a policy in place ahead of time. The other thing is that if you have a board policy where you say, all right, one DUI, we're just going to send a letter, unless you put that into regulation, unless you put that into law, then you're really acting outside of your parameters. We call that an underground regulation, because you're saying that and you're putting that direction out there as a board, but you're not actually formalizing it, you're not allowing for the commenting process. So if you wanted to put a regulation like that into place, that's what your disciplinary guidelines are for. You have a range of discipline that is possible under your disciplinary guidelines, and then it has to go by the special circumstances of each individual case and each individual.
Did you say each individual?
I did.
I thought I was just processing
He was just
that.
making sure you were listening.
I was trying to figure out a way out of the end of that sentence, and I couldn't get there.
There's a lot of individuality.
Yeah, I can see that. I can see that. Well, no. I appreciate the complexity of the situation, and in a certain way the function of the disciplinary guidelines. The fact is, I want to make sure that it's a topic of conversation that is brought up, and that there is no injustices done by the board. I certainly want to see justice done, but I want to avoid injustice on that.
Thanks, Alan. Any other board member comments?
I was just going to chime in on what Alan was saying, though, simply because of the cases. We see so many cases with DUIs where it's not the first but the second that we actually see something happening to say that they put on probation or whatever. So when we see those cases where there is no accident and there's one DUI, we have a concern, well, why is this one treated as if it was a second DUI when it was only a first? And I've questioned that myself, but I do hear what you're saying. I also understand what he's saying.
Any public comment? Okay, if not, that concludes the enforcement compounding report. Stan, you ready with licensing?
I can do it. In 2 notes.
Time's up.
In
Dating
2
yourself
notes.
there, Stan.
How does that, what do you mean in 2 notes?
I didn't understand it either.
Well,
That was Name That Tune. I know what
right,
that was.
long before your days of watching TV, there was a TV show, called Name That Tune. And somebody would, so they'd
Why
play
should
part
they
of
play
a
2
tune,
notes?
and somebody would say, I can name that
Oh,
in
that's
2
right.
notes. And
I had a board member that won $100,000.
Really?
I mean, not a
Really?
board member, a
now,
roommate.
this isn't an agenda item, and I want to apologize for that.
Let's go down memory lane. That's more fun, Stan.
It is. I like it. It's about all I have left these days is memory lane. So anyhow, the licensing committee, we had another exhilarating meeting on, before I start with the dialogue in our packet, I just want to say, and I said it earlier, and I'm going to say it again, and I'm going to thank Ann for the quote. Our ultimate goal on the licensing committee regarding the topic that we were discussing, excuse me, is to provide the pharmacist with more time to provide patient services, including drug utilization review, patient profile update, patient consultation, and a source of healthcare information. So to help accomplish this, our focus is now on the support staff of the pharmacists, and especially the pharmacy tech. At our meeting, we encouraged the stakeholders present at the meeting to give us their views, their opinions, their experiences, and especially their experiences and views if they had them from other states, what others are doing, such as Idaho. We had the fellow from Idaho make a presentation. So I ask you to accept the report I'm about to give. However, at this point, the committee has no actions for the board to consider. At our next meeting, we'll review the comparison data, and we will continue the assessment of the application and renewal requirements, as well as other possible changes in the duties of the techs, so the pharmacy techs. So having said that, Business and Professional Code 4202, and by the way, that is in your packet as one of the attachments, provides the general pathways to licensure as a pharmacy technician. In addition, California Code 1793.5, also in the packet, further details the application requirements. BPC, Section 4038, again in the packet, provides the definition of a pharmacy technician as an individual who assists a pharmacist in a pharmacy in the performance of his or her pharmacy-related duties. 4115 specifies that a pharmacy technician may perform packaging, manipulative and repetitive or other non-discretionary tasks only while assisting and while under the direct supervision and control of a pharmacist. 1793.2 specifies the duties that may be performed by a pharmacy tech. So the background is that the requirements for licensure as a pharmacy tech are fairly minimal. Let's underscore the word minimal. And they include 1, an application and a fee, 2, fingerprint background check, query from the National Practitioner Data Bank, and a description of qualifications and supporting documents. Acceptable qualifications include any of the following. 1, a completion of a technician training program. 2, certification from a specific program, currently either PTCB or EXCPT, and I think I saw somebody from there, but maybe not now. There. And an associate degree in pharmacy technology. The only requirement for renewal is a fee. So there's no continuing education, nothing extraordinary beyond sending a check to continue to renew your pharmacy technician's license. So pending changes, the board currently has a regulation pending to update the renewal requirements to also include self-reporting of criminal and disciplinary information. And the board adopted this regulation and is currently undergoing review by the Department of Consumer Affairs. Further, the board is also in the process of updating the application form by regulation to update reference to certification programs as well as to modify Title 16, 1793.6 to strengthen the requirements of pharmacy technician programs. And we talked about that at many meetings before. I know that Victor and Albert and many of the board, the committee members were very engaged in that. So prior to the committee discussion, during its June 2016 meeting, the committee heard the tasks performed by pharmacy technicians vary nationwide, and vary is an understatement. For example, in Alabama, techs may not handle controlled substances. In Utah, in addition to duties consistent with pharmacy technician duties, in California, pharmacy techs may also counsel for OTC drugs and dietary supplements under the direct supervision of a pharmacist, as well as accept new prescription drug orders left on voicemail for a pharmacist's review. In Alaska, if a pharmacy tech will assist in the preparation of sterile pharmaceuticals, the technician must have completed a minimum of 40 hours of on-the-job training in the preparation, sterilization, aseptic technique, and admixture of parental and other sterile pharmaceuticals before the pharmacy tech may regularly perform the tasks. So, as a summary of our discussion, the committee discussed the current application and renewal requirements. And that's something that we're certainly going to continue to discuss and look at very seriously as far as change is concerned. The committee discussed that if changes should be made to the renewal requirements to include completion of continuing education, the committee also sought clarification from those in attendance if requiring continuing education would become a barrier to continued licensure. The committee discussed the various settings where pharmacy technicians may be focused on different types of responsibilities to support the pharmacist. For example, a community pharmacy as opposed to a hospital pharmacy, et cetera, et cetera. And we requested input from the public on each of the settings. And we did have a lot of stakeholders in the audience, and if they were a little hesitant coming to speak, we encouraged them to, and they did, and we got a lot of good information. We noted the need to review the current marketplace and anticipate future needs when assessing the issue, while noting that any changes need to focus on how it will benefit the consumer, So such benefits could include pharmacists being available to engage in more patient care activities. That relates to some of the other discussion we had regarding of other systems rather than a pharmacist's direct contact with the patient. The committee heard public comment about how the role of the technician is evolving in other states, as well as recent studies in the area, including Tech in retail setting and a pilot program study in Iowa. For our next discussion, the committee requested that staff prepare a comparison of training requirements for some of the expanded duties currently being performed in other states. During our next meeting, we expect that the committee will review the comparison data provided and continue its assessment of application and renewal requirements, as well as possible changes in duties. Some of the large policy questions that we will be considering are whether there should be a creation of an advanced pharmacy technician license or a similar model, as well as if continuing education should be a requirement for renewal of a pharmacy technician license. And again, attachment number 1.
So could I just add a couple comments?
Say it again.
Could I add a couple comments?
I think any comment that you would add would be an asset to my discussion.
And if it's more than 2 notes, that's okay?
More than 2 notes is good.
Feel free.
2 notes is really the record if you want to go for it.
Well, I think I thought it was a great day.
It was a
myself.
good day.
And I think one of the things that also came out of this is we talked extensively about, okay, what do we do with the technicians we have today? And that maybe we kind of want to up the bar of technicians coming in so that possibly we don't need the advanced pharmacy technician. That might be something the employer kind of does that the Board of Pharmacy doesn't need to do. But in protecting the technicians that are out there today, one of the other states kind of did a grandfather thing so that we don't have a situation where we have these bunch of techs that are out there and we set this new rule and then they're all scrambling over what to do. We would basically have kind of a new license category where they could do maybe some other things and our grandfathered ones couldn't. So I thought I felt like that was maybe something that we were considering as kind of a solution to take care of the people that were out there today.
It's my hope that our committee is looking at the evolution of the practice of pharmacy,
Yeah.
how that evolves, and then looking back behind the counter as the evolution of support staff and how that is going to be able to further complement the job that the pharmacist is responsible for, and therefore the availability of the pharmacist for the purpose of community health.
Yeah, I thought that the comments, both from the committee as well as the people in the audience, the stakeholders, was how to provide a higher level of pharmacy care for the consumers in California and how to make it, make it a better place and deliver. And then another thing I know that came up and nothing was concluded, but I think one of the other things that kind of came out that we're going to have to look at is the ratios. It kind of came up and we kind of pushed it aside. We kind of said that's not the purpose of this meeting, but I know that was also discussed, and there was a great variety of opinions of even the committee members on how we might want to approach that. But I think that's something that's going to be part of our discussions going forward. Don't you agree?
Absolutely. And even as we look at tech,
Yeah.
well, tech, you're going to need more than one tech for there to be tech. And you're right. But again, the whole deal is we are looking to make changes for the purpose to benefit the community, to benefit the consumer, so that there's more availability of the pharmacist to the consumer. Making these changes for the benefit of volume behind the counter isn't the intent.
Of who behind the counter?
Volume.
Okay. I thought you said Ollie, and I was like, who's Ollie?
Increased volume.
Right.
I mean, you know, as everybody knows, I'm a real advocate for consultation. I think it's critical for the well-being of the health of our communities, and I think it's something that the pharmacist certainly is very, very capable of doing. And so, you know, my focus is getting the pharmacists out there and in the community setting where the pharmacist can really be an important part of the health team for the community for the consumer of California.
Yeah, and I was just reading that there's a state that's licensed farm techs to do immunizations now.
Yeah.
Right, I think it's Iowa.
Right?
No, not Iowa.
Well, Idaho.
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 Yeah. As a matter of
They're
fact,
now doing
I was talking
pharmac-
about somebody with that. Yeah, Idaho.
immunizations, right?
Right.
Which makes sense.
Well, it was interesting because Idaho did that with their techs, and actually there's one retailer that's doing it, but they went to Washington to get I think it's the College of Pharmacy in Washington, to train the techs in Idaho to do the immunizations in Idaho. It's kind of interesting, but yeah, I mean, Idaho they had some kind of, they had really broadened the scope of the technicians.
Yeah.
Remember that they had, 6 techs per pharmacist also?
Ratio is quite different than ours.
I mean, it was way.
So I just want the board to know that the committee is very engaged in this topic, and that we will continue to pursue it. We will come back to the board after we've vetted all these issues with recommendations to the board, once we are comfortable with what we hear and what recommendations we have to make. Like to add anything to that, Debbie? Debbie?
I was just going to say that I think that we're going to, probably one of the things the committee's going to have to do is maybe take it in chunks, and maybe our next meeting, we're going to have to figure out, okay, what chunk are we going to go after first? But, I mean, it's actually very exciting, because I think the committee is very interested in trying to look not just at the end of our nose, but ahead, so that, you know, we're not, because we feel like we're kind of behind the 8 ball, that we're behind times right now. And that's not what we do in California. We're usually ahead of it. So I do feel like the committee is very interested in trying to look to the future and make some hard decisions.
And I'd like to say, too, as a member of that committee, I do agree with everything that you're saying, and especially with SB 493. I think we really do need to employ the techs a little bit more because of what pharmacists are doing now that they weren't doing before.
Any other board members with remarks or questions?
Can I ask, if we were to establish an advanced practice technician, is that something we'd need to go to legislation for?
If you're going to license it separately, if they're going to have expanded duties, yes. Going to call them that, you might be able to get away with it without a statute.
Well, I'm just thinking like for things like sterile compounding and areas where you would want to have some specific expertise, it may be worthwhile to consider.
Then
Just
you'd have
curious.
statute.
Well, we actually looked at that a little bit differently, Amy. Instead of maybe having a different licensee type, we kind of liked what you guys did in compounding, where you said, you know, if a technician's going to be working in there, and I'm probably saying this wrong, but if a technician's working in there, that there's an expectation of training if you're doing this job, as opposed to creating a new technician level or something like that. So I think that we kind of felt like that might be a better way, a more flexible way to go than to have a bunch of different, even one additional, like an advanced practice tech, because we heard from a lot of the stakeholders, and there's like about 10 different ways you could have a more experienced technician work in a specific space, but it kind of differed by line of business and by practice site. And a lot of them already kind of figured out how they would get there, but we could probably just, to protect the consumer, just kind of put some rules around, maybe if you're going to be doing this and you have to have some, like if it's tech, check tech, then the tech that's checking the tech, maybe they have extra training or something, but kind of go about it, because it's kind of what you guys did in compounding. We thought that's probably more flexible and clever than having different categories. But who knows where we'll end up.
That's right. But the journey's a lot of fun.
Yeah. We hope.
Guys, in your journeys, geez.
Anybody else?
Sounds like work to me.
No. Anybody else around the board table?
We just said, though, that's almost like CE as opposed if you know, it's just like even with the pharmacists, if you're going to be giving out the naloxone, you're going to have a certain training, and the same thing with the techs. I agree with that.
Victor? Good. Any public comment regarding this?
Well, I'd like to commend the committee for
Thank you.
addressing this. Pharmacy has evolved. I've been doing it for over 40 years. And in long-term care, what you may not know is that in our particular operation, we probably have 40 to 60 new admits every day. And a new admit may not mean anything to a regular pharmacist, but we're reading an H&P and reviewing all hospital discharge orders, not the technicians, the pharmacists. So it'd be a huge help to be able to alleviate that. And our technicians, and I like the idea of having a ladder, because all of our employees are technicians, even our billing staff are licensed technicians. But it would be nice to give them an opportunity to grow and achieve something, a different level. So
I hope you will continue coming to our meetings.
I will.
And that you will make sure that we don't forget the tech in a.
Great. Thank you.
Stan Goldenberg. Again, congratulations on putting this into such a good focus.
Our president, who has taken me to the point of.
I would encourage you, okay, I would encourage you to reach out to the colleges of pharmacy. And when you and I graduated, Stan, we were...
They graduated stands.
We were supposedly set for 10, maybe 15 years of knowledge to carry us forward. I was just recently, as I told you before, at a College of Pharmacy advisory board, and the dean there shared that they're 5 to 7 years now. They're also creating pharmacist nurse practitioner programs, pharmacist law programs, and as Hal Wand was saying, and you'll find this out when you go back to the national board, that the technician is really the focus, the key on how safe medication is going to be dispensed. Whether or not a university is going to create a 4-year technician course or a 3-year technician course, they may be able to share that with you. But I think once you hear their vision, you put that with your vision, and then you can really get ahead of the game. Thank you.
Public input? Okay, so moving.
Just, if we were to do like Idaho does in terms of the immunizations, that would be a regulation? Statute? That would involve legislation. Okay.
You have to amend at least.
All right, thanks.
All right. Okay, so to continue on, our licensing stats, which are in attachment number 2, and I will not bore you with all attachment number 2, but licensing stats for the 9 months of this fiscal year. Licensing stats for 9 months of this fiscal year. The board has received only 12,673 applications.
Only?
Oh, yeah. Of which,
Pharmacists?
that's everybody. Almost 4,500 of them are pharmacy techs. Now, bear in mind, 4,500 pharmacy techs, 2,000 intern pharmacists, 1,500 pharmacists, and 164 advanced practice pharmacists. Now, that 164, that was really good to see, because although it's my hope that that will equal the same number we have of pharmacists someday, but at least we're seeing interest in it, and so hopefully the interest will continue to grow. As of March 31st, the board has issued 9,326 licenses. It's renewed 48,286 licenses, and we have 140,000 active licenses, including 45,000 pharmacists, 25 advanced practice pharmacists. However, bear in mind, 164 may be in the tube. Intern pharmacists, 6,857. And back to our pharmacy technicians, 72,480 and 434. That's significant, 72,000, 44,000 pharmacists, 8,162 pharmacies, and 516 hospitals and exempt hospitals. General processing information by site license type is provided in the packet if you're interested in it, reflecting data as of the 21st of April. The numbers reflect the time an application is received by the board through the time it is processed by licensing staff, which may include a deficiency letter being sent out to the applicant. If an incomplete application is received, there will be additional processing time involved. And as I said, there is a chart for your enjoyment if you would like to review it. And in addition to the general processing time, the processing time of evaluating deficiency mail of the site licensees is averaging 2 to 15 days, depending on the type of license. So, Madam President, if there are no questions from either the board and public, but it sounds like I have 2 notes coming.
You have 3 notes.
I was just curious, so 25 advanced practice pharmacists and 164 have applied. Do we see that, I mean, do we think, are those 164 that, like, most of them probably
A
going to?
good number of them. There are some people that are throwing in apps that are kind of hoping somehow they get licensed where they seemingly are not, they don't have the qualifications. I mean, it's pretty clear. But most of them, they're learning how to submit. In particular, the lack of a protocol for people that are using the protocol route seems to be one of the primaries. We're up to 61 advanced practice pharmacists too now, by the way.
We're at 61?
61, yeah.
That's pretty
As of, I think,
exciting.
this week.
And I see, you know, that USC and CPHA is out there with their program, so hopefully get some more.
CPHA has done a couple, I think they've done at least 3 graduations where they have the final assessment at the end, and CSHP hopes to do that when last I spoke with them in October when they have their annual meeting. So there'll be a group then.
What's our biggest increase been in terms of applications for licenses? Is it pharmacists or?
Without looking, my immediate reaction, well, probably sterile compounding if we're really talking about something, because the license is relatively new and everyone had to have one if they were doing it. But I think the techs, just without even really looking at the numbers, the techs and maybe the interns, but more likely the techs. It's just, there's a large number of them and they're constantly turning over.
And
Ones come in, new ones, old
one
ones
last
out.
question. You may recall when we had our board meeting in Glendale, I think it was maybe earlier this year.
Yeah, probably
We had a
December.
presentation about naloxone access and pharmacies that were not dispensing the naloxone. Did we refer that to the licensing committee for follow-up? What did we?
Public ed got it.
Public ed got it? Is that what it went?
Yeah.
Okay, so then I'll wait to the public ed report to see. Thank you.
Get ready, Victor.
Victor, you ready?
Already?
Communication and Public Ed Committee. Thank you, Stan, for a great report.
No, thank you
And
very
thanks
much.
for chairing the committee and doing an outstanding job.
Thank you.
Laura,
You want to take 5 first?
you want a break?
Oh, yeah, let's take a break. 10 minutes?
Yeah, I want them to be all awake.
Oh, yes, for you, definitely,
Go
Victor.
get some coffee.
Okay, we're back on. I'm with the video.
Oh, I was going, wait a minute, what
Okay,
are we doing
making
with the
sure he's
cameras?
ready. He's ready. Okay, Victor, Communication and Public Ed.
Yes, thank you. All right, the Communication and Public Education Committee, last meeting was held March the 23rd, 2017. Me being the chair, and my committee members are Debbie Veal and Ryan Brooks. A summary of presentation and proposal from Chapman University School of Pharmacy for patient-focused labeling changes to California law. The committee heard a presentation from Chapman University School of Pharmacy. The students regarding patient-focused labeling changes to California law. In a presentation led by pharmacy student Michael Pham, the students proposed the board mandate a standardized hazard symbol on prescription labels for new designated hazardous drugs. A copy of the students' proposal is in attachment 2. Mr. Pham noted that oral chemotherapy medications in particular are growing in use. He said mandating a hazard symbol on prescription drug containers would help improve safe handling and proper disposal of hazardous drugs. The students asked that the symbol be required on the main prescription label, not as an auxiliary or supplemental label, but not necessarily within the patient-centered area of the label. In response to questions from committee members and staff, the students said the FDA does not require a hazard symbol on medications, and they were not aware of any states that require a hazard symbol on labels. However, they noted California requires that compounding drugs be identified as hazardous. The students said they spent a year researching the issue, and they are now working with other groups around the country to educate and promote the idea among pharmacies, drug manufacturers, and other stakeholders. Ms. Veal noted that adding a symbol to the main label might be too small to be noticed, and suggested that an auxiliary label would allow a larger symbol to be used. The students said their research found that pharmacies often do not use auxiliary labels. They added that requiring the symbol to be located on the main label would allow for pharmacy software to automatically print out the symbol on the label and eliminate an extra step for pharmacists. Ms. Veal also asked if pharmacists currently could voluntarily put the symbol outside the patient center area, because the board's regulation specifies only what must be within the patient center area. Ms. Freeman said she believed a pharmacist could do that, but added that she would reserve the issue. In response to a question from Mr. Brooks, Ms. Freeman said rulemaking would be required for the board to mandate the symbol on the label, but would not be required for the symbol to be optional. Committee's members thanked the students for the presentation and expressed support for their efforts to educate stakeholders about the proposal as a first step before possibly seeking regulations. Ms. Veal said the committee would be interested in seeing the results of the students' survey of drug manufacturers about the issue. Ms. Harrell invited the students to write an article about their proposal for the script. Any comments from committee's member on this subject? Any comments from the public?
Only that I think that they had a good point.
Yes. Yeah, so we thank them for the effort.
And I would just add that it wasn't that I was trying to avoid responding to Ms. Veal's question and only responding to Ryan's. It was just that in the interim, I had been able to do the research.
Thank you, Lauren. Okay, going to item B. Summary of presentation by the Office for Civil Rights of U.S. Department of Health and Human Services on final rule implementing Section 1557 of the Affordable Care Act regarding non-discriminations in health programs and activities. Let me give you a little background. The U.S. Department of Health and Human Services issued a rule to implement Section 1557 of the Affordable Care Act, forbidding discrimination in health care on the basis of race, color, national origin, age, disability, and sex. The rule took effect July 18, 2016. The rule includes a requirement that healthcare providers that receive federal funding provide meaningful access to customers with limited English proficiency. The rule also requires providers to post taglines written in the top 15 languages spoken in the state by people with limited English proficiencies. Taglines are defined as short statements advising the public that interpreters and translation services are available free of charge. At previous board and committee meetings, members requested information about Section 1557 to determine whether the federal rule would have an impact on California laws and regulations, including requirements for prescription label translations. At the December 2016 board meeting, staff reported a possible conflict between the taglines requirements of Section 1557 and the point to your language requirements in CCR Section 1707.6C. President Gutierrez suggested the board refer the matter to the Communication and Public Education Committee to get answers to ambiguities to the federal rule. So this is an update. The committee heard a presentation about Section 1557 from Eric Press, an investigator in the HHS Office for Civil Rights, and a copy of Mr. Press' presentation is in attachment 3. After giving a broad overview of Section 1557, Mr. Press discussed specific provisions for communicating with individuals with limited English proficiency. The provisions include a requirement that healthcare providers covered under the law must publish taglines in significant publications in the top 15 languages spoken by the limited English proficiency individuals in the state. Cover entities also must post taglines in prominent locations and on their websites. Mr. Press said cover entities also must post notice of non-discrimination in physical locations where services are provided and in significant communications and publications. He said the notices must identify individuals' rights and the entity's obligations under Section 1557, and they must include taglines in the top 15 languages spoken by LEP individuals. In addition, Mr. Press said a cover entity must post a non-discrimination statement and 2 taglines in small size communications and publications. such as postcards and brochures. To explain the difference between notices and statements, he said notices of non-discrimination would be appropriate for posting in physical locations in stores and hospitals, and would include taglines in 15 languages, while non-discrimination statements would be appropriate only for posting in small-size printed materials and would have 2 taglines. Mr. Press clarified the point to your language tagline is different from the taglines in the federal rule, which are taglines printed on pamphlets, trifolds, postcards, and anything that is mailed out to patients, not on a notice standing in front of a person in a pharmacy. He said it is not for face-to-face communication. Mr. Press also said he did not think the tagline requirement would apply for a prescription medication container, not for written material handout with a container. He said the language assistance services would be provided at the pharmacy. Ms. Freeman added that Section 1557 requires non-discrimination statements for printed materials provided to patients, not for prescription labels. Committee members and staff asked questions about whether taglines would be required for other types of printed materials given to the patients, including printed package inserts and black box warnings provided by the manufacturers. Mr. Press said he could not answer specific questions about what documents would require taglines under Section 1557. He referred the questions about Section 1557 to the Office for Civil Rights website, which is www.hhs.gov/OCR. Ms. Harrell said the board may have specific questions later for OCR to ensure that California statutes and regulations comply with Section 1557. In response to a question from Mr. Brooks about the potential viability of the federal rule, Mr. Press said repealing the ACA also would repeal Section 1557. He added that whatever legislation replaces the ACA probably would retain the less controversial provision of Section 1557, including the LEP requirements. And there was no public comment. Okay, any questions from board members on this? None? Any public comments? Seeing none? Okay, let's move on to C. I know, kind of boring, okay? Hope you guys don't fall asleep. All right, number C. Update on NABP request to boards of pharmacy regarding labeling requirements for emergency use medications. I'll give you a little background on here. The NABP sent a letter asking state boards of pharmacy to review their requirements regarding the labeling of epinephrine auto-injectors and other similar emergency administration medications by dispensing pharmacies. NABP stated that EpiPens and similar emergency use products represent a unique category of medications that must be given special consideration regarding their expiration dates. NABP noted that many states require pharmacies to label dispense medication with a 1-year expiration date or with the manufacturer apply expiration date if less than 1 year from the date of dispensing. NABP requested that in situation where an EpiPen has not been removed from the original packaging, states allow a waiver for the EpiPen to be maintained and administered beyond the label 1-year expiration date through the manufacturer applied expiration date. And a copy of the NABP letter is attached in attachment 4. In the committee discussion, Ms. Veal and Ms. Harrow noted that the board does not have a 1-year expiration requirement that is mentioned by NABP. She pointed out the board has said pharmacists cannot put an expiration date on compounding medication that is later than any of the ingredients in the compound medication, or any date later than the date listed on the container by a manufacturer. Ms. Harrow said that as a matter of professional judgment, pharmacists know that if they have an EpiPen in a box that has never been opened, it can be used up to the manufacturer's date, even if it is outside 1 year. She said that the issue of expiration dates could be covered in a brief article in the script. Okay, any committee members, board members comment on this issue? Public comment? Seeing none? Okay, let's move on to D. Discussion and consideration of naloxone matters. 1. Update on federal legislation, USS 524, Comprehensive Addiction and Recovery Act of 2016, provision regarding partial fills for Schedule IIs. The background. At the September 2016 committee meeting, members discussed a potential conflict between Section 702 F2A2 of the CLARA and the California law. At the October 2016 board meeting, staff provided the following clarification from legal counsel. Pursuant to the Comprehensive Addiction and Recovery Act of 2016, 21 U.S.C. 829F, would be another situation where partial filling of a Schedule II controlled substance would be allowed, provided the prescription is a valid prescription and the pharmacist exercises their corresponding responsibility when filling a controlled substance prescriptions. 1. If requested by the patient or practitioner with no fill after 30 days from date written. 2. For a terminally ill patient marked as terminally ill, tender within 60 days from date issue and no more dispensing after 60 days from date of issuance. 3. For a long-term care facility patient marked as LTCF, tender within 60 days from date issue and no more dispensing after 60 days from date of issuance. 4. When a pharmacy doesn't have enough, dispenses a partial with the balance within 72 hours. Here's the update. Staff reported that an article about this topic is planned for the script scheduled for summer 2017. Ms. Harrow also informed the committee that the California Pharmacists Association is putting amendments into AB 1048 this year to amend state law to partial filling for 30 days. She noted that HSC Section 11159.2 exemptions allows pharmacies specially handling for hospice or terminally ill patients, and they do not have to use security forms. And there was no public comments on that. Okay, any comments from our board members? None? Public members? None? Okay, let's move on to 2. Summary of availability of naloxone at pharmacies in specific communities, including Los Angeles County. And here's the background. At the January 2017 board meeting, Dr. Rebecca Trotsky reported few pharmacies near Los Angeles County USC Medical Center carry naloxone, and most are not aware of laws allowing pharmacists to dispense naloxone without a prescription. She said that a survey by her medical students found that only 2% of independent pharmacies and about 30% of chain pharmacies carry naloxone in stock. She urged the board to provide more education and outreach to pharmacists about naloxone. Because Dr. Trotsky spoke about the matter that was not on the board meeting's agenda, so President Gutierrez invited her to speak about this issue to the Communication and Public Education Committee. So Mr. Trotsky addressed the committee by telephone from Los Angeles that date. She also was provided a copy of her student survey, which is included in attachment 5. Dr. Trotsky told the committee that when she prescribed naloxone to emergency patients at LA County USC Medical Center, many reported they could not get it from local pharmacies. She said, when her students called to investigate, they learned pharmacies were telling patients that they could not give naloxone without a prescription, and that they did not have naloxone in stock. The patient had to pay cash for it, and other responses that prevented patients from obtaining naloxone. Dr. Trotsky said her students' survey was conducted in December 2016 and January 2017. She said she wanted to work with the board to increase awareness among pharmacists about naloxone and to increase the availability of naloxone to patients without a prescription. Chairman Law, which is me, informed Dr. Trotsky of specific steps that board staff had taken to increase pharmacists' awareness of the naloxone since she spoke to the board in January, including emailing subscribers alerts, reminding pharmacists about the protocol in March, publishing an article about the protocol in a recent issue of the Script newsletter, posting information for licensees about naloxone in the board's website. He also noted that a training forum for pharmacists planned for March 11, 2017, including a session on naloxone. Ms. Veal noted that some pharmacists are not comfortable talking about naloxone with patients. Ms. Harrell pointed out that the protocol includes specific questions for pharmacists to ask patients. She said CE providers could emphasize training for pharmacists on asking questions and communicating with patients about naloxone. Chairman Law also said the board would like to take extra steps to educate pharmacists about naloxone and to educate consumers about where they can find naloxone. Dr. Trotsky thanked the committee and said she might conduct another survey in a year to see if the situation improves. Jonathan Bromfield of Adapt Pharma, the manufacturer of Narcan nasal spray, told the committee pharmacists nationwide often are not proactive about finishing naloxone because of the amount of time they are required to spend training patients or lack of reimbursement. Okay, board members, any questions on this topic? Yes, Dan.
So regarding reimbursement, is it a formulary item with regards to insurance carriers, and is it a formulary item with regards to Medi-Cal?
I don't think it's
The
a,
answer to that is yes.
Yes and yes?
Yeah, it is on Medi-Cal, the Narcan nasal spray is on Medi-Cal, and most insurances cover it.
I'm talking
Now-
about naloxone.
Narcan is naloxone.
on the patient though, it might not be for the caregiver.
Yeah, so that's the problem, is
That's
that
the
you have to
problem.
bill it to the patient. So if you walk in and you want to get it from me, because I'm, I have a problem and you just want to have it handy,
And we spend a lot of time together.
You would have to bill your insurance, but because you're not going to be using it, so that's really kind of what the quandary is.
So it can't be billed to your insurance? I go in and I say it's for Debbie Veal, and her doctor is
Yeah, but are
so-and-so?
you going to have my insurance?
No. I mean, I'm going in to get the naloxone for you. It's not like we have a casual relationship.
Right.
What was the do you know what's the liability if the Stan inject Debbie? If Debbie, something happened to her? I mean, the prescription, there's no prescription for Debbie, and then
Isn't there a
it's not
good-
for her, and then Stan got the prescription, got the drug, and then in case of your emergency, and he injected you, and you have some kind of complication from it, what's the liability on that?
Yeah, but
Well, I
forget the
took the
complication.
CE.
I've just saved their life.
Well, I just took the CE at LA Care. LA Care is actually, they've done actually 2 continuing education classes on naloxone. And they, you get, the pharmacist will explain to him exactly how to use the naloxone on Debbie. So.
I'm going back to CPR and mouth-to-mouth, Debbie.
Yeah. Just give me the naloxone.
Well, I mean, so, it would have been explained to you exactly how to give the naloxone in the continuing education
Right,
class.
I think, I think there's a good, and I'm definitely not an attorney, but I think it's a good Samaritan act, and, you know, if I'm dying and he administers naloxone, even if he does something wrong with it, I think he's trying to be a good Samaritan and save my life. I think that.
Yeah, and I'm going to ditto that. I can't give you legal advice about specifically, but I can tell you that such laws exist that are called Good Samaritan laws that generally protect people who are giving life-saving treatment. So, I mean, I don't know that it would apply in every situation, but I think that there's a reasonable expectation that if you're giving naloxone, that there's a very real risk of death.
I think the issue that Dr. Trotsky had raised was that there was no naloxone available, was the issue. I don't think it was so much a claim issue, but it was, yeah. Right, and I remember like only 20% of the pharmacies, so when they called, they told, she had a medical student call, but they said, we don't have it. So I think the goal was, what can we do to try to increase awareness of ensuring that it's stocked? And I thought chain drugstores had a greater number than independents.
Well, so I think there's a couple things that we brought up at the committee. One was the timing, like Victor pointed out, is that when she called, it was before the nasal was available, and so before that, it was you had to buy the injectable, and they came in boxes of 10. You couldn't get like just 1 or 2. Now you can get like 1 at a time. So there was some reluctance of pharmacies to actually stock it, because to order it, you had to order 10.
And they're expensive.
And, well,
Talking
it
about
wasn't.
the one that talks to you, or are you talking about the?
No, the Narcan is.
The spray, yeah,
is the
that's
nasal
new,
spray.
but before, you had to
Right.
buy the box of 10, is that the one that talked to you?
No,
That-
not the one that talks to you. It's the little injectables that you put the,
Oh, the injectable ones that you basically make
you
the
put
kits.
that you put the little nasal automizers on it.
Okay.
So there was a little bit of a problem there. And then also, I remember we talked a little bit about how they asked the question, and we thought that some pharmacies might have just, I think a lot of pharmacies weren't stocking it, but perhaps the way they asked the question was, and I don't have it in
Well,
front
I
of me,
mean,
but
a lot of pharmacists, they might not carry it, but if you ask them what they could, if they order for you on the same day, they would if you have a prescription. Like, they can't carry it on the shelf without getting any prescription by sitting there. So at least they have had some experience that they had some patient use it, or that you expect the doctor will prescribe for it, then you stock it. Otherwise, I wouldn't put an item on the shelf sitting there, for another month. I gotta pay for it, and then hoping that something could come in. But I could order it for them within the same day if a doctor said, "Well, they bring a prescription."
They're in crisis.
Yeah, that's the difference.
But most of the time, that's not when you're going to get it. It's typically in anticipation of that. You want to have it around, because that was one of the concerns when we were talking about the whole naloxone. Pharmacies were afraid people were going to come in and, oh, I'm high, and I need some right now. And it's more in anticipation, because when you're involved, when you're that high, you're not going to think about injecting yourself. So it's more like a family member or something to have in your, like an EpiPen, have it around just in case.
Okay.
That's why she, our discussion, she was kind of thinking maybe she would try to do the survey in a year because things had changed and more pharmacists were getting.
Was she at the meeting?
No, it was by
By
conference call.
telephone,
Oh,
yeah.
good,
She just
okay.
talked
So she said she's going to redo the survey?
She's thinking about it.
Right.
Right, okay.
Okay, any public comments on the issue? No? Okay. Yep, yes, sure.
Yeah, I just wanted to say that I see that as of May 3rd, 5 companies offering 75% off on Narcan. And it says it never expires, so there's a coupon now that's on the website
Is this for the spray?
for Narcan discount, 75%, never expires, valid as of May 3rd, 2017, CVS, Rite Aid, Walgreens, Kroger, Walmart.
The chair.
Okay, good. Good to know. Okay, all right, let's move on to number 3. Committee recommendation on the request from Walgreens to use in-house fact sheet for patients receiving naloxone. The background, Walgreens sent a letter to the board requesting approval to use a Walgreens-specific naloxone fact sheet for patients receiving opioid antagonists. The fact sheet would be provided to Walgreens patients whose primary language is English. For patients whose primary language is not English, Walgreens would provide materials printed in alternate languages that are on the board's website. CCR Section 1746.3b6 requires pharmacists to provide naloxone recipients with the copy of the current naloxone fact sheet approved by the Board of Pharmacy. This fact sheet shall be made available in alternate languages for patients whose primary language is not English. Copies of the board's online fact sheet in English, the Walgreens letter, and the Walgreens fact sheet are in attachment 6. And here's the committee discussions. Lori Rumsley of the Pharmacy Affairs Department of the Walgreens told the committee that Walgreens would like to use the Walgreens brand fact sheet that it uses in all other states to improve workflow. She said the Walgreens sheet contains all the same elements in the board's website's fact sheet. She said the Walgreens sheet is automatically printed anytime an opioid antagonist is sold. Ms. Freeman informed the committee that Section 1746.3b6 requires a single fact sheet that is to be made available on the board's website. She said Walgreens could submit the fact sheet for board approval and posting on the website, but Walgreens would have to give copyright approval for its fact sheet to be posted and made available for use by other pharmacies. Alternatively, Ms. Freeman said the board could modify Section 1746.3b6 to allow the board to approve alternate versions of the fact sheet. Ms. Wormsley told the committee that she would have to get corporate approval from Walgreens on the copyright issue. Ms. Veal noted that the board allows pharmacists to develop their own language for point-to-your-language notices, or to produce their own videos for the notice to consumers. Ms. Harrell pointed out that the regulation specifically allows for alternative forms and for videos for the notice to consumers. Ms. Harrell asked if Walgreens would be open to using the current fact sheet on the board's website if CDPH gave approval for Walgreens to load the fact sheet in the company's software. Ms. Wamsley said Walgreens does not have the ability to automatically print different fact sheets for different states. Ms. Ville said she would prefer changing the section 1746.3B6 to allow the board to approve alternative naloxone fact sheets rather than receiving individual requests from pharmacy chains to use their own fact sheet. The committee discussed whether the Medical Board of California would have to review changes involving the naloxone fact sheet, because the medical board was involved in developing the protocol. After the committee meeting, Ms. Harrell determined that the medical board would have to review any changes in the protocol, but not in the public education materials. So that's what the committee recommendation on changing CCR section 1746.3B6 to authorize the executive officer to approve substantially similar fact sheets for use so that the individual pharmacies can use them. And the committee support 3-0 on the vote. So this is a recommendation from the committee. Do we need a board vote on this? Is that right? Okay. Any committee discussion on this first?
Oh, as a matter of fact, I
Yes.
do.
Yeah.
Oh, okay.
Is your microphone on?
My microphone is on, thank you. I was on a roll there, and you kind of...
I'm sorry. I totally messed up your
Yeah, I
rhythm.
know. Anyway, esteemed board member Wong made a comment regarding naloxone in a previous board meeting, saying that when people came in for naloxone, that they obviously had some sort of addiction problem, and that oftentimes pharmacists would be asked and have no idea where to refer these people for treatment or help. And while it's not our duty to do that, it is our duty to help promote public safety. And so I would think that perhaps in the script or something, we could have some, or bring it up on as an agenda item or something to do about this, because people coming in for naloxone, they've got a problem, and if we can help refer them to some sort of rehab, to some sort of safe area, to something, we should have some of that information available that the public can access through us.
There is a group meeting in the California Department of Public Health that is looking at various types of components dealing with the opioid crisis. One of the items that they're looking at is treatment options available throughout California, because it is, after all, the Department of Public Health. There may be something at some point coming in that area. Right now, I'm not aware of a good list being available anywhere, and that's part of the problem. And then frequently, the treatment isn't available immediately, and that you have to wait 3, 4, 6 weeks, and it's expensive. And a lot of that's being done through ERs, oddly enough, or EDs. Of all the places, you wouldn't think that would happen. But anyway, so if you want to refer it to the Public Ed Committee, I think something ultimately will come up, but I'm not sure I'd want to hold my breath until something comes out of that group.
Well, I'd like to have it, a place mark or something like that in the agenda, because it's something that affects all pharmacies.
Okay, we'll take that to the Public Ed meeting.
Public Ed Committee. Okay. Okay. Any public comment on this subject?
I have one question. We have the fact sheet that we have on our website, which we got from the Department of Public Health in San Francisco. We have had it translated into 6 languages. Are we going to require, if we use one of, like Walgreens, to require them to translate it in 6 languages too, so that it's got equal availability for people throughout California?
Well, according to this report, Walgreens wanted to do their own in English, but in languages other than English, they were going to draw it from the board website.
Yeah.
So the only question would be, why can't they draw the one in English from the board website instead of saying, well, this peg has to fit in this hole, but we have a whole different shaped peg, for another segment of their customer base that's going to fit in a different peg.
I can let the Walgreens person come up, but as I
Person
recall.
here? Talk about a stroke
As
of
I,
luck.
no, so,
All right, coming up.
as I recall, it automatically
You do the
prints out
defense.
in English.
I know, but maybe I misread this. Here, hang on.
All right, go ahead.
Hi, Lori Walmsley from Walgreens Pharmacy Affairs.
What I'm referring to, great to see you. I'm glad you're here.
Thanks, Dan.
So in the background, it says, Walgreens sent a letter to the board requesting approval to use Walgreens specific naloxone fact sheet for patients receiving opioid antagonists. The fact sheet would be provided to Walgreens patients whose primary language is English. That's the Walgreens fact sheet. For patients whose primary language is not English, Walgreens would provide materials printed in alternate language that are on the board's website.
So the process that we're currently using today in California is our current, the Walgreens fact sheet is printing, so we're providing that, but then we are also going to the internet site, to the California Board's website, and searching for the appropriate one, whether it be in English or any of the other languages. It's really duplicative work for the store to print the California-specific one, and we're just looking to make sure that the process is as easy as possible for the stores.
Just seems to me, as little as this is being used. It seems to me, for as little as this is being used, the naloxone, the demand for it, to change a whole reg, when, if you're in a Spanish-speaking community, and the Spanish-speaking patients, and I don't mean to paint a broad brushstroke here, are the ones that you're going to be supplying naloxone for. So primarily, you're going to be going to the board's website and printing it in Spanish. I just don't understand why English is a big deal and Spanish isn't when it comes to the website.
I think the committee.
As far as asking for an accommodation from the board.
And I think the committee, so remember, we're Communication and Public Education Committee. So I think our viewpoint was, let's just make it as easy as possible to get the information out there. And so, and I think it's, so this is Walgreens in front of us, but I think if it was anybody, if there's anybody that wanted to make modifications and we did it in the, this isn't precedent setting, because we did it as far as, point to your language and, a couple other situations that we would make modifications. If it helped us get the information out to the public, then I guess we thought that that was a positive.
Don't deny that, but continuity is important as well.
Right, but that's why we would, that it has to be approved by the executive officer.
Consistency.
So as long as the executive officer says that, yes, the necessary elements are there, what difference does it really make that the format is the same?
So the instructions for a English-speaking Walmart naloxone patient could be different than the instructions for a Spanish-speaking naloxone patient.
No, it's all the same elements are there, it's just the format would be different. It would look
different because they actually look different if you look at the
right.
appendix.
They look different, but the information's the same.
We also have the wrong code section referenced. It should be C6, not B as in boy 6. It should be C as in camel 6.
I'm fine with it. It's just that it struck me as a
Yeah,
curiosity.
no problem. Any other questions for me?
You gonna run to the back of the room, Lori?
I'm good.
Stan?
I'll stay if you want.
Thank you.
Guys.
Thank you.
Okay, and this is the committee recommendations. Do we call for the vote? Amy?
Yes, go ahead.
Okay, all right. All those in favor, please raise your hand. Oppose? Abstain? And motion carry. All right, thank you. Let's move on to E. Update on the board developed public service billboard message and related communication materials. Here's the background. At the September 2016 committee meeting, members reviewed proposed concepts for a bulletin board message developed by Mr. Brooks' firm. The committee recommended the board proceed with a proposal featuring drawings of pews around the message, "Unattended drugs are the leading killer of kids." After the October 2016 board meeting, members agreed with the committee recommendation and voted to sponsor the billboard message. The billboard is intended to encourage parents to talk to their children about prescription drug abuse. And the staff reached out to Prescription Opioid Misuse and Overdose Prevention Work Group, which is a joint effort among state agencies. It is working to develop collaborative strategies to curb prescription drug overdose death and addiction in California. Staff is working to ensure that the board's billboard project is consistent with communication strategies being developed by the work group's Communication and Outreach Task Force. Ms. Harrell asked if it might be more effective if the board participated in the outreach campaign being developed by the statewide task force rather than proceeding independently. Committee members expressed concern that process for the task force campaign process would take too long and recommended that the board's billboard project continuing independently. Ms. Freeman asked if Mr. Brooks' firm had any concerns about sharing its intellectual property with state agency. Mr. Brooks said there were no concern, and there was no public comment. Okay, committee members, any comment on this billboard? No? Public members, any comment? Nothing? Okay, that's a good project. All right, going to F. Summary of discussion of efforts by drug manufacturers to stop illegal sales of non-FDA approved products. Here's the background. Representatives of Allergan met recently and discussed with board staff their concerns about the illegal importation of non-FDA approved products. They described Allergan's effort to shut down Amazon Medica, a foreign and unauthorized entity reported to be illegally selling Allergan's aesthetics products, including counterfeit products that are not FDA approved for use or for distribution in the United States. A copy of the information about Allergan's efforts against Amazon Medica is included in attachment 7. So Ms. Sodergren said that the board is aware of the problem and also is happening with other manufacturers. She said the board would be considering legislation dealing with this problem. There was no public comment. Any discussion of board members?
Is this the same Jeff Beddoes Amazon is this part of Amazon?
Not that Amazon said you buy stuff from.
Okay.
Any public members, public comments? Seeing none? Okay, let's move on to G. Update on communication plan for reaching consumers and licensees. At the September 2016 committee meetings, staff presented a draft communication plan that include aspects for both consumers and licensees. Staff developed the draft in accordance with the board's strategic plan. The committee approved the plan with continual modification and updates. Staff presented an update plan reflecting specific communication and public education activities in progress or planned by the board, including publication of the script, website improvements, subscriber alert, and CE. A copy of the plan is in attachment 8. So number 1, update on the script newsletter. The articles are undergoing legal review for publication, which is imminent. Update on the media activities. And the board executive directors participate in interviews and requests for information from the news media. And there are about 20 of those, which is printed on the handout. I'm not going to go through every one of that. Update on public outreach activities conducted by the board. There are also many public outreach activities by the board staff that includes which you see on the handout from, all the way from January to May, the inspectors or the supervisors, they have participated in different settings. So I'm not going to go through every one of them, but on future events, I'm going to tell you. October the 8th, Supervising Inspector Christian Acosta presenting at the California Council for the Advancement of Pharmacy annual meeting. Ms. Harrell provided an update on March 11 forum at UC San Diego. She said 225 people attended the event, and the board offers 7 CE units to the participants. In addition, 132 participants received naloxone certification. Ms. Harrell said participants asked good questions and that the ratings were good. She said that the event was videotaped and was being put online. In addition, she said organizers were asked to do the forum again, probably in Northern California. Lori Hensick of Kaiser Permanente asked if the board could provide an event like the March 11 forum, specifically for an employer or other organization. Ms. Harrell said the board would want to open up the event up. Ms. Sodergren added that any request to the board for an educational event must be made in writing. Chairman Law asked if the website has a master calendar listing outreach activities organized by professional groups that people can plan to attend. Ms. Harrell said that the board often does not receive event notice of events, and some are not open to the public. Ms. Sodergren said the board could create a calendar listing events sponsored by the board. And the staff is actually in the process of developing a mock-up of website calendar for the board's consideration. So a copy of the mock-up will be passed out as a handout at the board's meeting. And that's all the report that I have, Madam President.
Thank you. Victor, any board member comments?
Was the mock-up, was that in our materials?
It's under communication and public ed.
Very end.
Attachment 9.
Yeah, I mean, I like that because it's kind of more visual, you know, versus looking at the dates.
Yeah, thank you. Because that's the intention of the people could look up and go through the calendar and know what is expected, rather than go to each committee and go, this committee on this date, that committee on that date, and you're all confused what date is what date. Good job.
Looks good, Victor.
Probably Bob.
Oh, Bob.
Bob.
Thanks,
Good job,
Bob.
Bob.
Good job. All right, any other board member comments?
And it's actually been good for our committee to have Bob, because he's been able to, you know, he's been very active and gotten a lot of information out there. So we appreciate our new public information officer. Is that is correct. Very good.
Thanks.
Thank you, Bob.
All right, well, now we actually have tomorrow morning, we have the presentation on the board's pharmacist recovery program first thing. And then we will do ledge reg and finish up the meeting tomorrow. We will now go into closed session.
Okay, one thing, the presentation that's going to be given tomorrow is actually printed in your binders that you have. If you want
Okay.
to look at it tonight and think of any questions that you might have for the
Okay.
presenter.
And they're going to be here right when
I believe they're the first thing on the agenda
First thing
tomorrow.
on the
since we
agenda?
did,
What time?
I think 9 o'clock. 9 o'clock tomorrow.
9 o'clock tomorrow? Okay. So I just wanted to acknowledge that we skipped around on the agenda just to ensure that we'd have enough time to get through the full agenda. And so now we will go into closed session for some of the cases. We'll probably have to finish tomorrow.
Yeah, we can certainly start the closed session,
Yes.
and then to the extent that we need to, you
Yep.
can recess,
Tomorrow.
return.
We can finish it up tomorrow
in
after the meeting.
After you finish the open session items.
So we will now be moved into closed session.
So just for clarification, we will come back into open session, but only to recess.
Yes.